Please be seated. The sitting is open. For reasons duly made known to me, Judge Abraham is unable to join us for this afternoon sitting. The court meets this afternoon to hear the United Kingdom, Slovenia, Sudan, Switzerland, Syrian Arab Republic, and Tunisia on the questions submitted to it by the United Nations General Assembly. I recall that each of the delegations has 30 minutes for its presentation. This afternoon, the court will observe a short break after the presentation of Sudan. I shall now give the floor to the representative of the United Kingdom, Ms. Sally Langrish. You have the floor, Madam.
Thank you. Mr. President, members of the court, it is an honour to appear before you on behalf of the United Kingdom. In participating in these proceedings, the United Kingdom underlines its respect and continued support for the court. Our position on the Israeli-Palestinian dispute is long established. We firmly believe that a negotiated two-state solution is the only way to end Israel's occupation, to deliver Palestinian self-determination, and to preserve Israel's identity and security. That belief is founded on the relevant Security Council resolutions and the parties' existing agreements. Recent events only reinforce the importance and urgency of implementing the existing framework. On the 7th of October, Israel suffered the worst terrorist attack in its history. Hamas's terrorist attacks and the ensuing conflict in Gaza have resulted in tragic and large-scale loss of life and injury to civilians. Palestinians now face a desperate humanitarian crisis in Gaza. The United Kingdom wants to see an immediate suspension of the fighting in Gaza and then progress towards a sustainable and permanent ceasefire. It is essential to ensure irreversible momentum towards a two-state solution, guaranteeing security, justice and peace for both Palestinians and Israelis. The United Kingdom has only addressed matters of propriety in its written statement rather than the merits of the request. It takes the same approach in these oral submissions. In doing so, the United Kingdom should not be taken to accept any factual allegation or legal proposition advanced by other participants. Over the course of this week, we have heard certain characterizations of Israel's actions which we don't accept. We have also heard characterizations of our own conduct and the motivation for it, which we emphatically reject. We are confident that the court will find analogies with unrelated cases to be entirely unhelpful. What matters is the case before it today. The United Kingdom confines its submissions to relevant matters of legal principle, firmly founded on the court's own jurisprudence. We submit that the terms of the request do not allow the court to give an opinion in a manner consistent with its judicial functions. The United Kingdom will focus today on 3 key points concerning propriety, which will be developed by Professor Saroushi. They are: first, the impact of the non-circumvention principle in this case. Second, the unsuitability of the fact-finding exercise that the court would have to conduct to answer the request as presently framed. Third, the effect of Security Council resolutions 242 and 338. Each of these points independently provides a cogent reason for declining to answer the request. The court will have observed that our third reason has occupied a particularly prominent place in the participants' oral submissions. Should the court be minded to issue an opinion, then the United Kingdom would respectfully urge it to reformulate the questions to concentrate on the Security Council framework. In this scenario, the court should focus on assisting the General Assembly in supporting urgent progress towards a negotiated solution. I will address this point in concluding the United Kingdom submissions later. But first, Mr. President, I invite you to give the floor to Professor Saroushi to address the issues of propriety.
Thank you, Ms. Langridge. I now give the floor to Professor Saroushi. You have the floor, sir.
Mr. President, members of the Court, it is an honour to appear before you on behalf of the United Kingdom. I shall first address the non-circumvention principle. The Court's jurisprudence has long recognised the distinction between its advisory and contentious jurisdictions. The Court has held consistently that its advisory jurisdiction cannot be used to undermine the fundamental requirement of state consent. Further, it should not provide a form of judicial recourse for parties, nor should the Court resolve disputes between parties using its advisory jurisdiction. Instead, the Court's advisory function is to offer legal advice to the UN organs requesting the opinion in order to assist them in their activities. Let me be clear. The United Kingdom does not submit that a state whose rights or duties may be affected by an opinion can prevent the Court from giving an opinion. Rather, consistent with the Court's jurisprudence, the United Kingdom's submission is that where a request is, I quote, directly related to the main point of a dispute between two parties, then the Court should refrain from giving an opinion. In the words of the Court in Western Sahara, to give an opinion in such a case, I quote, would have the effect of circumventing the principle that a court is not obliged to allow its disputes to be submitted to judicial settlement without its consent. Close quote. If the Court were to answer the request as currently formulated, it would entail a breach of the non-circumvention principle. The United Kingdom makes 4 points. The first relates to the nature and content of the bilateral dispute. It is more than a mere difference of views. It is a dispute of acute sensitivity. It is long-standing. It concerns the status of Israel's occupation, issues of security, and the conditions under which Israel can and should withdraw from the occupied Palestinian territories. Second, the request engages that core dispute. The General Assembly asks the Court to consider in express terms and rule on both the legal status of the occupied territories and the legal consequences of that status. The Court is also invited to make findings of Israeli responsibility in relation to its policies and practices. This engages key permanent status issues which are at the heart of the Israeli-Palestinian dispute, including on Jerusalem, on settlements, on security arrangements, and on borders. Indeed, a key participant has described the Assembly's request as taking the entire Palestine question to be looked at by the highest court in the globe. The third point concerns the relief requested. The Court is asked to determine that Israel's occupation is unlawful and to order that Israel should withdraw immediately from the occupied territories as a result. Over the course of this hearing, the Court has repeatedly been requested to order Israel's immediate, unconditional, and total withdrawal. This repeated insistence further demonstrates that the Court is being asked to decide the main point of the dispute, which several states recognise. Finally, Israel has not consented to the main points of the dispute being resolved by this Court. To the contrary, it has asked the Court to refuse to respond to the request. Given the content of the request as currently formulated, there is thus no basis on which the Court should answer it. Participants have identified two main counter-arguments as to why the Court should proceed to answer the request. First, they say the court can determine key issues relating to the parties' bilateral dispute because it is of broader concern to the UN. Their argument relies on the court's recognition in the Wall opinion that the General Assembly has a permanent responsibility towards the question of Palestine. The result, they say, is that the request arises, quote, in a much broader frame of reference than a bilateral dispute. With respect, the United Kingdom disagrees. The General Assembly's consideration of a bilateral dispute does not mean that the non-circumvention principle is inapplicable. If it did, the principle would never apply in any advisory proceedings, since any bilateral dispute on which the Assembly made a request would always fall within the so-called broader frame of reference. Such an approach would deprive the non-circumvention principle of all practical application. This approach to the United Kingdom is consistent with the Wall opinion. That opinion did not concern the core aspects of the Israeli-Palestinian dispute. The court itself accepted that it could not properly address what it referred to as the greater whole of the dispute. Judge Higgins characterized that approach as wise and correct. Judge Karoma was careful to distinguish the request in the Wall case from any such broader request that concerned the Israeli-Palestinian conflict as such or its resolution. And Judge Awada accepted that the court's answer should not, quote, be tantamount to adjudicating on the very subject matter of the underlying concrete bilateral dispute that currently undoubtedly exists between Israel and Palestine. A related point that several participants have advanced is that the Israeli-Palestinian dispute is multilateral in character because it concerns erga omnes obligations. The fact that a bilateral dispute may involve obligations in which states have a collective interest does not obviate the need for consent for that dispute to be resolved before the court. Nor does it change the fact that there are two participants involved in that bilateral dispute. The second counter-argument on non-circumvention is that the non-binding nature of advisory opinions means that a court can opine on a bilateral dispute. Like the first argument, this would deprive the non-circumvention principle of all practical application. By definition, Mr. President, all advisory opinions are non-binding, and so the principle would never apply in any advisory proceedings. This ignores that the court is being asked to make findings about Israel's liability and responsibility for various alleged breaches of international law that are central to the bilateral dispute. The court would in substance be deciding on the main points of the dispute if it were to answer the request as formulated. And that is precisely the problem that the non-circumvention principle is intended to avoid. This submission also ignores that serious legal consequences may result from the court's findings. This risk is even more pronounced since several participants asked the court to make legal determinations for the express purpose of clarifying the law relevant to the parties' negotiations. In sum, the principle of non-circumvention is engaged in this case. Mr. President, members of the court, if this fundamental legal principle is ever to have any real meaning or application, the court must decline to answer the request as currently formulated. I now turn to the United Kingdom's argument concerning the court's factual inquiry. Let me be clear. The United Kingdom is not questioning the court's competence to make factual findings. The court can, of course, do so, and the United Kingdom does not suggest otherwise. Nor is there any doubt that the information and evidence available to the court is voluminous. Rather, it is the sheer scale and complexity of the factual determinations that would need to be made by the court in these advisory proceedings, which is the problem. The United Kingdom is not the only participant to raise this issue. Allow me to highlight a few features of the factual determination process in this case. The request in the present case makes no attempt to set out its factual basis. This stands in stark contrast to the Wall opinion. In that case, the request by the General Assembly was based on assumed facts described in a single report by the UN Secretary-General. As one key participant accepts, and as the court's jurisprudence reflects, this means that it is for the court, in exercising its judicial function, to independently evaluate the factual materials that have been submitted to it. In this case, the request asks the court to determine a long list of legal issues and make the necessary factual findings to support them. This is by reference to the entire factual record stretching back some 57 years and a UN dossier spanning nearly 30,000 pages. As a matter of practicality, it is unclear how the court can properly make the broad range of findings required to answer the request and consider such a volume of material, especially when exercising its advisory jurisdiction, where the court cannot fall back upon considerations of burden of proof. It is no answer to assume that the court can defer to the reports of UN bodies. The court must reach its own independent findings of fact. We emphasise that several states, including the United Kingdom, have expressed reservations about these UN reports. The court's task is further complicated by a factual landscape that's rapidly shifting in the context of an ongoing and active conflict. This creates the serious risk that the court may draw legal conclusions on an incorrect factual basis. The problem is further heightened by the gravity of the accusations levelled against Israel, where it is not a party and where the proceedings have been expedited. As this court has long recognised, quote, claims against the state involving charges of exceptional gravity must be proved by evidence that is fully conclusive. In sum, the United Kingdom submits that there is a serious risk that the court may undermine its judicial function by giving an advisory opinion in such a context. Mr. President, members of the court, I now turn to the existing framework, the third point, for resolving the parties' dispute and its impact on these proceedings. The court is well aware of the agreed framework for a permanent settlement of the parties' disputes as contained in Security Council Resolutions 242 and 338 and in the parties' interim agreements. The precise terms of Resolution 242 are worth recalling. They identify the two interdependent principles of withdrawal and security, to which the court was referred on Wednesday. To be clear, this resolution does not determine that the occupation is unlawful. The terms of the resolution make this plain. The Security Council and the General Assembly continue to endorse this framework. Most recently, in December 2023, the Council affirmed its unwavering commitment to a two-state solution. Both organs also continue to recognise that a permanent settlement requires a negotiated solution under the auspices of the UN. Many states in these proceedings have emphasised the need for a negotiated solution and the importance of preserving the agreed framework in the context of these proceedings. The United Kingdom shares these views. The parties' agreed framework provides a further basis for declining to answer the request. That framework envisages the negotiation of Israel's withdrawal, not a court decision requiring it. In response to this submission, three main points have been raised by other participants. First, it is said the negotiation process has been stalled for some time. This does not negate the validity of the Security Council framework, nor does it change the reality that a negotiated solution under the UN's auspices is the only possible way in which the conflict will be resolved. It underscores the need to strengthen that process rather than undermine it. Second, some participants have referred to the court's jurisprudence on whether it should take account of adverse political consequences when considering propriety. The court's jurisprudence requires there to be an objective basis to assess the relevance of such consequences. In this case, there is an objective basis. It is the established Security Council framework. The General Assembly's general mandate in respect to the Palestinian question cannot override the Security Council framework. Third, it is argued that an opinion will not interfere with the Security Council framework or with negotiations conducted under its auspices. Instead, it is claimed an opinion will assist that process. Participants rely on the court's statement in the Wall opinion that the negotiations must be conducted in accordance with international law and equivalent language in Council resolutions. And so the court's legal conclusions can and should, they say, constrain the bases on which those negotiations are conducted. With respect, Mr. President, this argument is flawed. It would undermine the very premise of the Council's framework if the court were to address the status of the occupation and require Israel's withdrawal. As I observed earlier, that framework inextricably links withdrawal with security and applies on a reciprocal basis. An unconditional order directed at only one party contradicts that fundamental requirement. It also undermines the additional premise that Israeli withdrawal will be achieved by negotiation rather than by court opinion. Furthermore, an opinion addressing the parties' obligations would prejudice their negotiating positions and thus contravene the court's injunction in the interpretation of peace treaties and the Western Sahara advisory opinions. That, I quote, "the legal position of the parties to a dispute cannot be in any way compromised by the answers that the court may give to the questions put to it." For these reasons, the United Kingdom respectfully requests the court to decline the request as presently formulated. Mr. President, I now invite you please to give the floor back to Ms. Langrish.
I thank Professor Saroushi. I now give the floor back to Mrs. Langrish. You have the floor, Madam.
Thank you, Mr. President, members of the court. So Professor Saroushi has explained why the court should decline to answer the request. But if the court is nonetheless minded to provide an opinion, the United Kingdom proposes an alternative course, which seeks to respect the existing framework and ensure the parties' compliance with it. We foreshadowed this approach in our written statement. It is firmly rooted in the court's jurisprudence. Let me start by recalling the court's recognition in the Wall opinion that the resolution of the dispute requires the implementation of Security Council resolutions, in particular resolutions 242 and 338. This, in turn, requires a negotiated solution to the outstanding problems and the establishment of a Palestinian state existing side by side with Israel. Judge Higgins was even more prescriptive. She rightly observed that the resolutions embody key underlying requirements for the resolution of the Israeli-Palestinian dispute, namely that Israel is entitled to exist, to be recognized, and to security, and the Palestinian people are entitled to their territory, to exercise self-determination, and to have their own state. Judge Higgins further recalled that Resolution 1515 of 2003 envisages that these long-standing obligations are to be secured both generally and as to their detail by negotiation. Her view was that the court, and I quote, should have used the latitude available to it in an advisory opinion. And she reminded both parties not only of their substantive obligations under international law, but also of the procedural obligation to move forward simultaneously. The United Kingdom's position on the principles for the implementation of Resolutions 242 and 338 has long been clear. First, there must be an agreement on the borders of the two states based on the June 1967 lines with equivalent land swaps between the parties. Second, security arrangements for the Palestinians must respect their sovereignty, and for Israel, they must protect its security. Third, a just, fair, agreed and realistic solution to the refugee question must be put in place. And fourth, the aspirations of both parties for Jerusalem must be fulfilled through negotiations on the status of Jerusalem as the future capital of both states. The United Kingdom agrees with those states that urge the court not to cause prejudice to the existing Security Council framework or to decide any aspect of the parties' bilateral dispute. Like other participants, the United Kingdom recognises that an alternative route to respect propriety is to reinterpret the request or reformulate its terms. There is no question that the court has the power to proceed in this way. It has often been required to interpret or even reformulate the questions put. As Judge Tomka has acknowledged, the court can avoid intruding on a bilateral dispute by narrowing the scope of its answer. The question for the court is how best to achieve these aims. We propose that the court's opinion should focus on endorsing the continued application of the agreed framework with a view to ensuring its urgent implementation. An answer of this kind would respect the three propriety limitations that we have identified. It would also assist the General Assembly to discharge its mandate on the Palestinian question, which many participants have emphasised is the object of this request. More specifically, the United Kingdom in this alternative submission respectfully invites the court to do the following: to endorse the continued application of the Security Council framework to both parties and the need for its urgent implementation at the earliest possible opportunity, to recall both parties' obligations to respect the terms of the Council's framework, to recall both parties' agreement not to aggravate their dispute by taking any step to change the status or integrity of the occupied territories until a negotiated solution is agreed. And lastly, to reaffirm the parties' obligations in their interim agreements that they negotiate on permanent status issues. In this way, the court could assist the General Assembly in achieving its stated objective, which is to support urgent progress towards a negotiated solution within the Security Council framework. The United Kingdom reiterates that a negotiated two-state solution is the only way in which the Israeli-Palestinian conflict will be resolved. Mr. President, honourable members of the court, thank you for your attention. That concludes the United Kingdom submissions.